Hello and welcome to Legacy IAS Academy. Government has recently introduced 130th Constitutional Amendment Bill. Now, because it's a constitutional amendment bill, it would require majority of the 2/3 of members of Lok Sabha as well as Rajya Sabha. But this bill intends to, they say, as the government is introducing the bill, they have stated that this intends to clean or decriminalization of politics is the primary aim of this bill. Before we delve into how exactly what are the provisions that are aiming for decriminalization of politics, I have a brief news to be information to be covered that we are starting up with our new batch in the month of September as well as October. 22nd September and 16th of October will be our regular batches, that is weekdays batch, and weekend batch will be starting from 4th and 25th of October. We will not be delving into the details. I'll just tell you about some of the most important things related to the classes being taken at Legacy IAS Academy. The overall batch size is quite small, that ensures the faculty is able to give individual attention to every candidate. But despite of all of this, if the candidate wants to meet the faculty separately or the mentors separately, we do have option of one-to-one mentorship as well. Additionally, there will be regular MCQ as well as answer writing discussions, answer writing classes that will be going on along with the subject itself relevant to the topic that has been covered in the class. So, if you want to join the course, you can dial on the number that is mentioned below or scan this QR code or click on the link that is mentioned below the description box. Now, talking about the provisions exactly, how are we intending to decriminalize our politics? So, talking about the provisions of this bill. So, the bill intends to remove the ministers. Now, that is important because so far we have had such provisions under ROPA, Representation of People's Act 1951, where not a minister but an MP or an MLA can be removed from their position. So, this bill intends to remove a minister only if there is arrest and detention of the minister for a period of 30 days for an offence. That offence has a penalty of more than 5 years. So, if an offence has been registered against a minister and that offence ends up into a penalty of more than 5 years and the minister has been arrested as well as detained, so that minister will have to resign. Now, who will ensure his resignation will be the Prime Minister or the Chief Minister. So, on the advice of the Prime Minister or the Chief Minister, the minister, that is Council of Minister at the central government level or Council of Minister at the state government level, the minister will have to resign on the advice of PM or CM. Now, what if that minister doesn't resign? So, on the 31st day, when the 30 days period gets over, on the 31st day, there will be an automatic resignation. So, the minister will be automatically removed on the 31st day. 30 days ka detention period, arrest and detention period is over. So, 31st day, the minister will be removed. Now, this is regarding the minister. What if the Prime Minister or CM himself or herself has to be removed? So, then they have to carry out immediate resignation. They must resign on the 31st day itself. So, there is nobody to advise the PM or CM. They must themselves resign on the 31st day. Now, there can be reappointment. Once that custody period is over, that police custody period is over, and we found that the person is not convicted, then that can be he or she can be reappointed as per the provisions of this bill. Now, what are the existing laws? As we discussed, Representation of People's Act 1951 has stated so far that if an individual, that is an MP or an MLA, who has been convicted and sentenced for a period of more than 2 years, जिनको conviction कर दिया गया है, मतलब judiciary has passed that this person is convicted and this person is sentenced for more than 2 years, then this will be disqualified, that individual will be disqualified as a member of Lok Sabha or Rajya Sabha or Legislative Assembly or Legislative Council. So, as an MP or MLA or MLC, that person disqualifies. अब ये disqualification कितने duration का होना चाहिए? That disqualification is equivalent to the total sentenced period along with 6 years. So, that sentenced period तक that person cannot contest for the post of MP or MLA or MLC. Additionally, for 6 more years, that person cannot contest for the post of MP, MLA or MLC. Okay. Talking about the recommendations of Election Commission. So, ECI has recommended that it basically has barred, ECI has recommended, now this is not applicable so far. Election Commission of India has recommended that we should bar the candidates from contesting if the penalty is more than 5 years. So this is basically an implementation of the recommendation of ECI itself, but this is for ministers, not for MP or MLA. Okay? The bill is not for MP or MLA, this is basically ministers. Now talking about the issue which is the most important part, because it has been stated in bureaucracy that the policies should not be judged on the basis of the intention. What are you intending to do? The intention is very clear, that we want a decriminalization of politics to take place. That intention is very clear. But it should be judged on the basis of the actual results. So we need to critically analyze the bills that have been passed in parliament, at least for the bureaucracy, for the post of bureaucracy. It is imperative that you must judge and analyze every bill on the basis of their pros as well as cons. So far we have studied about the provisions, fine. What are the existing laws, ROPA? What are the recommendations regarding ECI? Recommendations coming from ECI, but what about the issues? What about the issues with respect to this bill? The first and most important issue is that if the police has taken that individual into custody, MP, that minister is under custody, police custody for 30 days. So now we are disqualifying a minister to hold that post just on the basis of police custody and not on the basis of judicial custody. It is ultimately under the purview of the judiciary to decide whether a person is actually a convict or not. So until and unless judiciary says so, we should not be removing a person from the post. Okay? So that is very, very obvious that on the basis of police action, the minister can be removed from their post. Very important, because we are not, ultimately this is a kind of media trial. So media has trialed on the basis of partial information, media has trialed, carried out a trial, and whatever has media stated, this is what is the penalty, that person is convicted. But media doesn't carry out investigation, police carries out investigation, and despite of investigation, the judiciary has to decide whether the person is actually convicted or not. So whether this person should have been removed from the ministerial position or not should be under the purview of the judiciary and not police. First important issue. Second important issue, that it undermines the parliamentary democracy. Kyunki parliamentary democracy में we have given the right to the prime minister or the chief minister that अपने council of minister को आप select कर सकते हो. Now if he has or she has selected a council of minister and on the basis of police custody only, you are removing the person from the ministerial position, that it is undermining the power of the prime minister or the power of the CM to determine his or her own council of ministers. Now this will tend into this direction, that the CM will have to basically put those ministers in their council of minister who is appealing or appeasing the central governments or the prime minister. Okay? Third important issue is the risk of misuse, that this can be misused. Let's say you have a central government, a political party, let's say A, and the state government has another political party, let's say B. Central government wants to remove one person from the council of ministers, or let's say the CM of that state itself. The political parties are not same. So they can initiate a judicial proceeding, they can initiate a police proceeding, and only for a custody of 30 days that CM will lose their post. So it can be misused by the central government to remove a person from the post of the either CM or the council of minister. Okay? Fourth and final issue is the bill is dealing with the effect and not the cause. Basically, the effect is that the politics has been criminalized, that we do agree. That is the effect. But what is the cause? What is the reason? We have not dealt, or this bill has not dealt with this fact, that why did the government appoint, why did this person got appointed to the post of minister at the first place? That was the cause. We have had such kind of cases wherein the minister is having criminal background and has been appointed to the post of to the government, to the council of minister. So if we would have dealt with this kind of appointment itself, we would have dealt with the cause. As of now, what we are dealing with is just to ensure that the minister will not be ruling the government from inside the jail. The minister is inside the, we have had such cases. For example, Representation of People's Act 1951 states that MP or MLA gets disqualified, the ministerial position is not getting disqualified. So the MP or MLA ka post has gone, but that minister is inside the jail. Now, the minister also has 2 months of time period just to prove that he or she can become a member to the parliament or member to the legislative assembly or legislative council. So basically, the issue with this bill is you are not dealing with the cause. Why did the government, why did that political party appoint such kind of person? That would have been the cause. As of now, what we are dealing with is the minister is being appointed in that government, and we are just ensuring that that minister should not be ruling the government, should not be part of the government from inside the jail. So that is the issue with respect to this bill. Now with that, we come to the end of the discussion with respect to 130th Constitutional Amendment Act. As of now, it has been referred to the Joint Parliamentary Committee, and that will help us decide what will be the fate of this bill. I wish you all the very best, and thank you so much.